So we have a lot to get started and go over today, so let's just jump to it. Again, today's topic is appellate issues at trial. Just a little bit of background. As an appellate lawyer, I often attend trials with trial lawyers, and I know firsthand the amount of preparation and work that goes into preparing for trial. And there's many, many different preservation issues that you need to be aware of through all stages of a civil trial. And that's pre-trial, trial, and post-trial motions. And what I'm going to attempt to cover today is just generally the main issues to be aware of. And since this is such a huge topic, really what I'm trying to do is just provide you with a broad overview. I could literally spend an entire day just talking about preservation of error and appellate issues at trial and do a full day's presentation. And we only have 50 minutes, so I'm going to do the best I can to try and hit the highlights and just the takeaways that you should be aware of. So let's just talk about basic rules of preservation under Florida and Texas law. And these are pretty applicable in most jurisdictions. In order to preserve error, you have to make a timely and specific objection. And in order to preserve the issue for appeal, your objection cannot be, the next day. It can't be in a late filed motion. You have to do it contemporaneously at the time, and you have to be specific, because if you're not specific as to what the specific grounds for your objection is, typically it's not going to be preserved for appellate review. So in Florida, at least, proper preservation of error generally requires three components. You must, and this we're talking about at trial, you must make a timely, contemporaneous objection at the time of the alleged error, state the legal ground for that objection, and be specific as to the legal ground or the basis for the objection. Meaning, if you didn't make it clear on the record at trial, you're not going to be able to bring it up later on appeal. Just some general case law on this. The Ailes case, the Florida Supreme Court, a ruling on the objection is required. So even though you might be very clear and specific and timely with your objection, make sure you get a ruling from the trial court in order to preserve that issue. Either it's sustained, overruled, but just get a ruling. Texas, the test for whether an issue is preserved for appeal is whether the party made a specific objection and obtained a ruling. So again, very, very similar, if not identical to Florida. There's a rule of appellate procedure in Texas, 33.1, that discusses this. And I've also provided you with a couple of cases if you want to look into this a little bit further. But these are just basic rules of preservation of error under Florida and Texas law. Also, Florida and Texas both require that evidence must be proffered in order to preserve the issue for appeal. And here's a few cases that discuss proffering of evidence and that requirement. Well, the issue comes up and you might think, well, what does it mean to proffer evidence? Usually, the whole issue of proffering arises when the trial court denies or excludes certain evidence from being presented to the jury. Well, you don't agree with that. You're at trial. What do you do in order to preserve that issue for appeal? In Florida, when the trial court excludes certain evidence, the party seeking to introduce that evidence must make an offer of what is proposed to be proven in order to preserve the matter for appeal. And this is necessary to enable the appellate court to determine whether the proposed evidence is even material. I'm sure many of you in Florida folks are aware of the harmless error standard. So the appellate court needs to know what that evidence is in order to decide whether or not it's material and whether or not it could be harmless error by virtue of the exclusion. So that's proffering of evidence in Florida. And keep in mind, too, I do want to point out, as I said at the very beginning, this is going to be a very broad and general overview. Of course, there's many nuances to all of these general rules that are beyond the scope of this presentation, but there is case law out there that talks about a proffer is not required where it would be useless, a useless act, or futile, or the trial court has already specifically rejected an entire category of evidence. These exceptions are typically very rare, and if you're not sure, you always want to err on the side of making a proffer if you want to preserve the issue for appeal. And I also just want to mention that we are going to be discussing motions in limine a little bit later in this presentation, and there's some important considerations to keep in mind related to whether or not a proffer is required when you've obtained a definitive ruling on a motion in limine. So again, this is just a broad overview. There's many, many different nuances in the case law, and sometimes there are exceptions. Texas, what does it mean to proffer evidence? Well, in Texas, once the trial court has ruled or otherwise excluded the evidence, the party must, during trial, approach the bench and ask for a ruling, formally offer the evidence, and obtain a ruling on the offer. So really, it's virtually identical as Florida in terms of what does it mean to proffer evidence and how do you preserve that issue for appeal. And the Ferguson case is a recent case that discusses this process and what's required in Texas. Moving on, invited error. Some of you may have heard this term, some not, but this is something to keep in mind because it does affect your rights on appeal as to whether or not you potentially, by your actions in the trial court, invited the error that you later complain about on appeal. In Florida, the invited error doctrine basically means that a party may not make or invite error at trial and then take advantage of the error on appeal. And the Sheffield case is probably a pretty well-known case on this issue, Florida Supreme Court 2001. It talks about what does that mean exactly. Well, some things might technically be error that you request or ask for at trial, and you can't later go back and challenge that ruling by the trial court if somehow you've agreed to it or were complicit with it. And that's kind of a complicated way of just saying that if you ask for or invite error at trial, you're stuck with it. You can't challenge that later on appeal. Texas recognizes the same doctrine, and it's basically the same as Florida. And again, it prevents a party from complaining on appeal that the trial court took a certain action when the party had requested same at trial. And I've included a few cases that discuss this doctrine under Texas law, if you are interested in those. Depositions and error preservation. I get questions on this a lot. And of course, there's many depositions that are usually taken as part of the whole pretrial discovery process and filed for use at trial. Of course, you don't call every witness live at trial, and oftentimes you will read many different deposition transcripts and excerpts from depos at trial. So the issue sometimes arises, and the questions that I get, well, what do you need to do at a deposition or later at trial to preserve issues related to that deposition for appeal? Well, in Florida, the failure to object to questions and answers during a discovery deposition does not amount to a waiver of the right to make a substantive objection later at trial. So you always preserve your substantive objections, including hearsay or there's other basis why the testimony should be excluded for trial. But you do need to make any kind of objection as to the form or, the form of the question, the manner of taking the deposition, the conduct of the parties, any kind of error that could have been obviated or cured if presented at the time of taking the deposition, that must be made while the deposition is ongoing. So those depositions, you always need to make those or they're waived. They are not preserved for appeal. Substantive objections you can make later at trial. So that's Florida. Texas, interesting, they have a very specific rule on objections at deposition in Texas, and those are governed by Texas Rule 199.5E, and that lists the only permissible objections that may be made at a deposition. And in talking with Texas attorneys, my understanding is you have to actually use the language, the specific language, and are limited only to the language and the rule, which is very interesting to us Florida attorneys because we don't have anything like this. In Texas, objections to questions during oral depositions are limited to objection leading and objection form. And objections to testimony during the oral deposition are limited to objection non-responsive. So you have objections to the questions that counsel's making, and then you have that one single objection to testimony during the oral deposition, which is just objection non-responsive. And these objections are waived if not stated as phrased during the oral deposition. And all other objections need not be made or recorded during the oral deposition to be later raised with the court. Now, the objecting party, according to the rule, must give a clear and concise explanation of an objection if requested by the party taking the depo, or the objection is waived. Argumentative or suggestive objections or explanations waive the objection and may be grounds for terminating the oral depo and for sanctions. So it's all set forth in the rules in Texas, which is very interesting, but certainly something to be aware of if you're deposing somebody, if you're a Texas lawyer deposing a witness in Texas. Moving on to pretrial stipulations. These, I cannot emphasize enough what a great and useful tool stipulations are in preparing for trial, no matter where you are, but particularly in Florida and Texas. And frankly, in my opinion, I think they're underutilized. To the extent that you can get an agreement on the other side as far as facts, evidence, issues, you avoid the unnecessary presentation of evidence to a jury, and they are binding on the parties, as we'll discuss. In Florida, pretrial stipulations are binding on the parties and the trial court. A great case on this is the Central Square Tarragon case, and also a recent case out of the 3rd DCA is this Beachcomber Jewelers case. Texas, the same way. Pretrial stipulations are authorized. They're a binding contract between the parties and the court, and you can stipulate to the issues to be tried along with facts. And if you do have this kind of stipulation, it limits the issues to be tried by the jury, and those are properly excluded from consideration. Now, a stipulation as to certain facts obviously obviates the need for proof of same. But one caveat just to keep in mind is, and this really applies to Florida as well, is that while parties may stipulate to facts, neither the courts or the parties are bound by stipulations to legal conclusions to be drawn from the facts of the case. So that's just a nuance to be aware of, and this Basic Energy case basically discusses that point. But for the most part, stipulations are great. They're underutilized. If you can reach an agreement with the other side, it really helps, and those will certainly be recognized by the appellate court should the issue go up on appeal. Moving on, let's talk a little bit about pretrial, trial, and post-trial motions under Florida and Texas law with a focus on preservation of error. And again, this is just a very broad overview. I'm not covering every single different motion that could be brought or you should be aware of as far as appellate preservation, but I'm just trying to hit the highlights and the ones that I think will probably occur most frequently. Motions in limine. Motions in limine are pretrial motions that seek a preliminary ruling, usually on evidentiary matters, and they're usually to exclude evidence. One thing to keep in mind, and I've actually experienced this, is sometimes you will receive motions in limine that really go well beyond just trying to limit the presentation of evidence to the jury at trial, and really they are being used as unwritten or unnoticed motions for partial summary judgment or to dismiss a claim. If you see those kinds of motions that are really just overly broad or too comprehensive, and they're really just trying to strike a whole theory of your case or a cause of action, this Brock case is a great one to keep in your back pocket, because that's really not the purpose of a motion in limine. Motions in limine are pretrial motions, essentially tools that to basically clean up a case before it goes to a jury, keeping out prejudicial, inadmissible, or other evidence that for whatever reason should not be presented. let's talk a little bit about motions in limine in Florida. And just I want to highlight it before I get into this. There are some definite important distinctions and differences between motion in limine practice in Florida and Texas. So keep that in mind as we go through this. In Florida, a definitive ruling on a motion in limine preserves the issue for appeal. So that's one of those things where if you've gotten a definitive ruling on a motion in limine before trial, the issue is preserved for appeal, and there's cases that say that you don't have to raise the issue or objection again at trial. Often, though, many attorneys do, just in an abundance of caution, because it can't hurt. But let's talk a little bit about what does that definitive ruling mean. Well, sustaining an objection is not a definitive ruling, and that's in the Greenwald case, Florida 3rd DCA. And a tentative ruling is not a definitive ruling. So a definitive ruling is basically the trial court explicitly stating one way or the other, the motion's granted or it's denied, the evidence may be presented or it cannot. If the trial court basically says, well, I'm going to reserve and consider, we'll see what happens as we move along, the issue is not preserved for appeal. Instead, at that point, you're going to need to proffer the evidence and get a definitive ruling. And again, this Philip Morris case, brand new, just came out this year, 4th DCA, when a trial court declines to rule on a motion in limine or defers a ruling until trial, the party must make a specific and contemporaneous objection at trial or the issue is waived on appeal. So important considerations to keep in mind when dealing with motions in limine in Florida. Texas, very important distinction. In Texas, a definitive ruling on a motion in limine does not preserve the issue for appeal. If you want to read a little bit more about that, Dallas County case here, it's a Texas Appellate Court case, a good opinion to read. But in Texas, they basically consider it, this is a preliminary ruling, and it's just not a ruling on the admissibility of evidence. So if a motion in limine has been granted, to preserve the error, the party seeking to introduce evidence must approach the bench, ask for a ruling, formally offer the evidence, and obtain a ruling on the offer. So proffer the evidence, just like we discussed a little bit earlier. That's what you have to do in Texas, regardless of a ruling on a motion in limine. Very important distinction. Motions for mistrial. Again, I'm not going to talk about every particular scenario or possible scenario in which a motion for mistrial may be required in order to preserve the issue for appeal. I'm just going to try and hit upon or touch upon what I think may come up most often. Motions for mistrial in Florida, most of the time I see these for attorney misconduct and proper closing arguments. And in Florida, in order to preserve for appellate review a sustained objection to an improper argument or attorney misconduct, a motion for mistrial must be made at the time the improper comment was made. And that's the Campagnoni case versus City of Tampa, Florida Supreme Court, 2010. And note, I mean, courts have said even if you receive a curative instruction, you must still move for a mistrial if you don't think that curative instruction was good enough. There's other cases that talk about that a motion must be made promptly, although not necessarily contemporaneously. Definitely you want to err on the side of caution there in terms of timing. You may also request that the trial court reserve ruling until after the jury returns a verdict. That's again in the Campagnoni case. And keep in mind, if your original objection was overruled, you do not need to move for a mistrial in order to preserve the issue for appeal, and that's in the Goff case. And another, in terms of improper closing argument, the Murphy case is a case to be aware of. To me, this is very much an outlier case and its exception. And basically, in Murphy, if for whatever reason you didn't object, you really didn't preserve the error as to improper closing argument properly in the trial court, Murphy kind of gives you sort of a catch-all, a test for when where the judgment could be reversed when you didn't object, but really the argument was so over the top and improper that essentially the fundamental error exception will apply. So if you, in one of those kind of cases, and for whatever reason you didn't properly preserve your objection to the improper closing argument, the Murphy case certainly is one you want to be aware of in Florida. In Texas, a motion for mistrial is not required to preserve an objection to improper conduct by opposing counsel. In Texas, a Condra case discusses the standard, and in Texas, the way they look at it is they don't want to incentivize attorneys to behave badly and force the other side to request a mistrial. And there's several cases that discuss this. So it's interesting how Texas approaches this, but it's certainly different from Florida. So again, another important distinction to be aware of between the two jurisdictions. Motions for directed verdict. Many of you are aware of these. They're made all the time at trial, and really what happens is a motion for a directed verdict is essentially a test of the sufficiency of the evidence that was presented at trial. If an essential element has not been proven or established, a motion for directed verdict should be made. In Florida, a defendant must first move for a directed verdict at the close of the plaintiff's case and then again at the close of all of the evidence in order to preserve the issues for appeal. And that's pretty standard. So keep in mind, just making a motion at the close of the plaintiff's case does not preserve the issue. You have to make it again at the close of all of the evidence in order to preserve any issues for appeal regarding the sufficiency of the evidence. And if you don't do that, you're not going to be able to raise that issue on appeal. And keep in mind, these motions are, it's usually a very difficult or standard to make. If there's any probative evidence at all on the element of the claim, most likely the motion will be denied. And it's also a very difficult standard, the sufficiency of evidence standard, to take up on appeal. So that's just something to keep in mind. Texas, again, similar to Florida. In Texas, motions for a directed verdict, they have specific rules and standards that govern these. And in Texas, a trial court properly directs a verdict if a specifically indicated defect in the opponent's pleading makes it insufficient to support a judgment, or the evidence conclusively proves facts that establish the movement's right or negate the non-movement's right to judgment, or the evidence raises no fact issue on any material fact that the non-movement must establish to prevail. So that's basically a lot of words that provide the same standard, essentially, as Florida. And again, it's a difficult standard. Most of the time, these motions are very difficult to have granted. Here's some other different caveats and issues to be aware of in Texas. An objection raised for the first time in a motion for directed verdict does not preserve the issue for appeal. And if you introduce evidence after a motion for directed verdict, this apparently constitutes waiver in Texas. So that Bryan versus Dockery case can provide a little bit more insight as to that issue. Post-trial motions. Well, there's many, many different post-trial motions that may be made and that are necessary in order to preserve all issues for appeal. We're going to go through some of the more common ones, and of those, motions for judgment notwithstanding the verdict. In Florida, if a party moved for a directed verdict at trial and that was denied, the party should move for a judgment notwithstanding the verdict in a post-trial motion if you want to preserve that issue for appeal. So if you move for directed verdict at trial and this was denied, and you want to bring up the issue of sufficiency of evidence on appeal, you must file a motion for judgment notwithstanding the verdict. Now keep in mind, this motion can be and is often joined with a motion for a new trial. And again, a motion for a new trial is also required to preserve any issues related to the sufficiency of the evidence. Now, also keep in mind, if you did not move for a directed verdict at trial, you're not allowed to file a motion for judgment notwithstanding the verdict. It's not authorized, and that's discussed in the Siegel versus Cross Senior Care case, which is a recent Florida 3rd DCA case. Texas. Again, Texas is similar to Florida. If your motion for directed verdict was proper, then a motion for judgment notwithstanding the verdict should be made. And again, the judgment notwithstanding the verdict, a motion is proper when the evidence is conclusive and one party is entitled to judgment as a matter of law, or a legal principle precludes recovery. And I've included a few cases here if you want a little bit more information about what the standard is in Texas, but it is very similar to Florida. The Netco case a few years ago, in a Texas appellate court case, provides a good explanation of what the standard is and when this motion is proper and when it's not. Jury instructions, verdict forms, and jury selection issues. Many, many appellate issues arise over these issues, and I'm going to try and provide you with just a broad overview of some of the more common issues that may come up. Jury instructions in Florida. Well, in Florida, we have a Rule of Civil Procedure 1.470, and this rule actually requires that the trial court conduct a jury charge conference, and that's where you go over all of the proposed jury instructions, and the trial court should rule on any objections as to any instructions at that time. And keep in mind, this rule too also provides that really in Florida, you're supposed to use the standard jury instructions, and if you want to deviate from that or use any kind of special instruction, the trial court's required to make specific rulings along those lines and why that is being authorized. And a jury charge conference, you're always going to want to have a court reporter, and the rule specifically provides that no party may assign as error the giving of any instruction unless that party objects thereto at such time, meaning the jury charge conference, or the failure to give any instruction unless the party requested same. So unless you requested a certain instruction be given, including a special instruction, unless you made that request and had it recorded at the jury charge conference, that issue is not preserved for appeal. And I do also want to highlight that you always want cases where somebody will just refer to the standard and jury instruction, which might not necessarily be filed, but it's always helpful just to file the standard jury instructions. There's forms, so it's easy to do, and that way there's no dispute whatsoever. Verdict forms in Florida. One thing to be aware of, and that frequently comes up on appeal, maybe not so much now as it in the past, is the two-issue rule, meaning the use of a general verdict. And that means that when there are two or more issues are left to the jury, any of which may be determinative of the case, and a general verdict is returned, which makes it impossible to ascertain the issues upon which the verdict was founded, reversal is improper if, as to at least one of the issues, there was no error. And the Colonial Stores case, it's Florida Supreme Court 1977, is sort of the main landmark case on this. So that's just something to be aware of. So verdict forms are important. Again, make sure that those are any dispute as to the use of a certain verdict form. You're going to want to put your objections in writing. You're going to want, if you have a hearing on it, make sure you have a court reporter, and just make sure that all of this is preserved in the record for you to take it up on appeal should you so choose to do so. Inconsistent verdicts. If you believe that the jury has come back with an inconsistent verdict, you must bring this to the attention of the trial court before the jury is discharged and request reinstruction if needed, or the issue is waived for appeal. And this is just one of many cases on this issue. Florida Department of Transportation at the Florida 4th DCA 2003 case. So you can't complain about an inconsistent verdict later if you did not bring it to the attention of the court, the trial court, before the jury is discharged. So you always want to do that. And err on the side of caution. You might say, I mean, if you look at this Florida Department Transportation case, it sort of explains a little bit what is considered an inconsistent verdict. We could spend a lot of time just discussing that point alone, but if there's any issue as to whether or not the verdict's inconsistent, bring it to the attention to the trial court at that time and request re-instruction if you want to take up that issue on appeal. Jury selection issues. In Florida, in order to preserve objection to the jury, including any jury selection issues, you must object at trial to the jury as finally composed. Meaning, before the jury is sworn, you need to state your objection on the record. Many cases on this. This Miami elevator case is just one of many. If the trial court refuses to strike a juror for cause, this is in Florida, you must exhaust all peremptory challenges and make a request for additional peremptory challenges in order to preserve this particular issue for appeal in Florida. So it's another jury selection issue, an appellate preservation issue in Florida. Moving on now to Texas, jury instructions. To preserve the error of an omitted instruction, meaning that you wanted a certain jury instruction and the trial court refused to provide it, 3 steps are required. A proper instruction must be tendered in writing and requested prior to submission. A specific objection must be made to the omission of the instruction, and the trial court must make a ruling. So it's similar to Florida. I mean, you basically need to make a record. You need to make sure that you have your specific written instruction that you want to use. You must make sure that you object specifically on the record as to the trial court's failure to utilize that instruction, and make sure that the trial court makes a specific ruling. Why is this instruction not being used? Make sure the trial court rules on that. Verdict forms. Again, errors in Texas, very similar to Florida. Errors must be brought to the trial court's attention before the jury is discharged to preserve issues for appeal. Always err on the side of caution along those lines. Jury selection issues. In Texas, they have case law, basically the Batson issue, which is when you believe that there's racially motivated strikes to certain jurors. For appellate review, you must make those type of Batson issue objections before the jury is sworn. And that's the Jones v. Martin case. It's an appellate court case in Texas. That's basically our presentation today, Appellate Issues at Trial. If you have any questions or concerns, if you'd like a copy of the PowerPoint, please feel free to contact me at any time. I have my email, crooney@butler.legal, my phone number, direct line, 813-594-5153. I'm happy to answer any questions or to discuss any of these issues further with you. And I realize we covered a lot of information very quickly, and this really could be a full-day presentation. If you would like a live presentation on this topic or any other topic, please feel free to contact me. I'm happy to come to your office and do that, and also arrange for credit for that presentation. I will be doing the next and final webinar for the Appellate Webinar Series, and that's December 12th at 12:10 p.m. And this will be on a case law update for 2018, and I'm going to cover all of the significant cases in Texas and Florida that happened this past year that you should be aware of that could potentially involve appellate issues, insurance practice, any significant issue, case law or ruling that you should be aware of. So that should be a great webinar, and I hope you'll be able to join me. Again, that's December 12th. I also wanted to let you know that I'm currently planning my 2019 Appellate Webinar Series. I'm happy to consider any requests for any certain topics to be presented. If you would like me to cover a certain issue or topic, please email me or call me and let me know, because like I said, I'm still planning the 2019 Appellate Webinar Series, and I'd love to present an issue or topic that you would like to hear. So I welcome any suggestions. So that's it. Again, you should be receiving an email from Jackie Bing, Florida Adjusters, and if you have any further information about CLE or CE credit, please feel free to email me or give me a call. And thank you so much for attending today, and have a great rest of the day. Thanks so much.